I'm Nikki Jovicic from Lookupstrata. I'm also the Managing Director of Tower Body Corporate, and I'm your host. Welcome to today's webinar, providing valuable insights into the latest developments in strata building defects claims and the associated legislation in New South Wales. David Bannerman from Bannermans Lawyers is joining us today to cover duty of care under the Design and Building Practitioners Act 2020. David will also discuss the process and consequences of building works rectification orders, your coverage and rights as a homeowner, legal protections for major and minor defects, and the implications of the 2% or now 3% bond scheme. What are the requirements of the BBPA, the standards expected of building practitioners, and the potential consequences of breaches? Now, today is a New South Wales session. While some aspects of some of our state-based sessions are applicable in other states, today's session is really heavily based on New South Wales legislation and may not be applicable in other areas. Before we begin, I'd like to mention that the information in this session, including the discussions arising from submitted questions and chat conversations, is not advice and should not be relied upon as advice, and you should seek independent advice before acting on the information contained in the session. We're very happy to welcome back David Bannerman, Principal of Bannermans Lawyers. David is a qualified lawyer. He is an accredited property law specialist with the Law Society of New South Wales, with over 15 years extensive experience in all aspects of property law and building litigation. David has a keen interest in education and training. He demonstrates his commitment by regularly presenting educational seminars to strata managers, developers, insurers, lawyers, and other stakeholders in the strata industry. David's extensive experience in the legal industry and the courts allows him to provide practical, cost-effective legal solutions and training on the latest developments in the law. His insights are delivered in a clear and helpful manner. So welcome, David, and thanks so much for joining us again today.
Oh, thanks so much, Nikki. And thanks and good morning to everybody in the audience. Lots of people there in strata land. Feel free to ask those questions as we go. I'll cover what's in addition to what was mentioned, but what's trending at the moment as well, because there's been a few developments in the space since that invitation went out. So I will go through what I've seen as trending. So just sort of starting with the basics for the audience. So a defect, well, it's something that causes a loss in relation to building works. It might be causing a water leak is an obvious one, or it might cause a rectification order from council in relation to fire defects, or it might cause something to collapse or be destroyed. That sort of leads you into, in New South Wales, the government likes to change the definitions of things every few years. Many years ago when I first started, you had structural defects, and then when you had major defect, and then you had a different version of major defect, and then under a new rewrite, due to probably be launched next year, they're going to go back to structural defects. So these definitions change from time to time, and it leads to a lot of litigation trying to work it out. But at present, in today's environment, a major defect is a defect in the fire measure, cladding which is causing a safety issue, a structural issue, and a waterproofing which is going to cause the building to collapse, be destroyed, or you can't use it. So that's pretty severe in relation to the consequence. So you could have a water problem in a bathroom, but if it's not going to cause the building to collapse, be destroyed, or you can't use it, then that's not going to be covered by a major defect. So the reason for this distinction is that you have a longer period of time to bring an action for a major defect than any other defect, which is a minor defect. And in New South Wales at the present time, for all defects, regardless of whether they're major or minor, you can, if you bring the action for your claim against a builder, a developer, or in rare circumstances against a subcontractor within 2 years of completion of the works, you can recover all defects. A lot of owners corporations, unfortunately, don't make enough moves in time within that 2-year period, and so they don't get the minor defects covered, and they're left claiming the major defects. And we'll talk about what owners corporations are doing now, because they frequently took too long to take their action. And an action would mean getting a report and filing an application in the court or specialist tribunal. And that sort of leads you to the next question of, well, if I've got problems, and water leaks are an easy one to address, because that's usually the catalyst which causes owners corporations to take their action because there's mould, there's lots of rent claims, that it's causing health risks. And so who's responsible? Well, in New South Wales, it's everyone in the supply chain now except the certifier. So that could be supplier of the product. We'll talk about a class action against the product supplier of cladding shortly. It could be the engineer, it could be the architect, the builder typically will be in the frame, the developer, if there was more than 4 or more units, they'll be in the frame for liability. It could be the home warranty insurer if it was less than 4 stories. Could be subcontractors. So everyone in the supply chain is now responsible for defects under the new laws, under the Design and Building Practitioners Act, which I'll explain more shortly. But those claims are a lot more difficult to progress. And I'll talk to you about some of the progressions of the understanding of the law, because it only started in June 2020. And we'll talk about, but under the statutory warranties, you've got the builder and developer. So they're typically the ones who are held accountable in New South Wales. It's very different in other states. Now, what the government has sought to introduce, because they don't want to insure for buildings that are 4 or more stories, is a 2%, and now from July from July this year, a 3% bond scheme. So this is based off the contract price, and it's a bond which is held by fair trading. It's not like a bank guarantee, so if the builder goes insolvent, it could be clawed back into the funds of the by the administrator, and then the owners corporation would get just whatever cents in the dollar out of that. So, but it's money that's been held aside to keep the developer from just folding the company when he's received the sale proceeds, so he can knock on the builder's door to get him to come back and fix things, and so that that would then lead to the builder knocking on the subcontractor's door, so they would come back and fix things. Now, that hasn't really covered that many strata buildings in New South Wales, because a lot of people, when this started on the 1st of January 2018, just entered into contracts just prior to that to avoid that having to happen. And so it hasn't been a proliferation of the 2% bond scheme as much as what fair trading was hoping, given they gave like too much warning about how to avoid it. So a lot of people avoided it. And then they've worked out that 2% is not a sufficient sum to cover the defects. And the idea is that it's only sort of held for a maximum term of 3 years. And so they've changed the 2% to 3% from July. So you won't see that for quite a while, for some years to come. As a strata manager, you won't be accessing 3%, you'll be at 2% for quite a few years to come. So that's a change that you'll see in the future, but it's not thought that 3% is adequate. The ratios that the government thinks would be more adequate would be if that was 5% for 6 years. But what they have sort of introduced, which is a decennial insurance product for developers, could actually obtain that instead of putting up 2 or 3%. Now, because there was a lot of avoidance of the 2 and 3% bond scheme, and because there was a lot of work that was uninsured, the government introduced the Project Intervene, which was an expansion of their powers when they do a licensing investigation, and which could result in an order. And that closed on November 2023. And in our experience, Project Intervene takes a really long time and covers not a great proportion of the defects that would otherwise be identified by an independent consultant. But a lot of people need to be aware that it doesn't extend the statutory warranty period. And if you don't take your action within the relevant 2 or 6 year period, you lose your statutory warranty and the person is absolved of the debts under the statutory warranty scheme. So if you have, got a claim in with Project Intervene and you're waiting for it to be resolved and you've got a pending 2 or 6 year warranty period about to expire, you need to file your application while that's being continued by fair trading. So don't forget that your warranty period is not being extended by an application to project intervene. So how do you work out your warranty period? Well, you need to get advice about this because there's a lot of errors that typically happen. So if it's a new building, it's from the first occupation certificate for the whole building. Sometimes that can be an interim occupation certificate, sometimes it cannot be an interim occupation certificate, it needs to be the final. So you need to get advice about that. And it runs from whichever is a valid occupation certificate. So that's for a new build. Now, if you've got a retrofit building, or you're doing remedial works, that's a different start time. It's when the works were reasonably capable of being used. And they can look at all sorts of indicia to work out when it can be reasonably capable of being used. That could be an occupation certificate. It could be a certificate of practical completion that was issued under a contract. It could be a declaration from a builder that the works are reasonably capable of being used. So it would certainly be before the date of the occupation certificate, because it would have been ready before that application was lodged. So care needs to be worked out, advice needs to be taken about when that warranty period is due to expire. So where does home warranty insurance come into play? Well, it's for 3 or less story buildings, and it's the most valuable right in the statutory warranty defect space. It's valued at $340,000 per lot, government-backed funds. It's far in excess of 2% bond, which, if you looked at the 2% bond contract price in comparison, that would be $12,000 per lot on typical average 600,000 build versus $340,000 under the home warranty insurance scheme. That sort of $12,000 is not backed, it's not guaranteed, could be clawed back by a liquidator. So there's some real problems with that scheme which have yet to be fully thrashed out. But if you've got home warranty insurance rights, you've got to notify your home warranty insurer within 6 months of being aware of a defect. You want to make a claim as soon as you're able to before the relevant period lapses. Otherwise, you'll find yourself in court arguing that the insurance has lapsed or that you did not notify the insurer within the relevant period of time. So now, cladding, a big issue throughout the world. You had the Grenfell Tower cladding case finally determined some 7 years, and then that was more like an inquiry, and then from that there'll be litigation to flow and people pursued and all sorts of actions yet to come. Now, Australia also has an action going at the moment. It's a Aluka bond and Vitra bond cladding class action. It was lodged before July 2019 and was listed for a 2-month hearing, which started about a month ago. And that hearing is heard, so it's still going through the case. And who knows if there'll be appealed or not. But what's interesting about cladding class action is that for the strata managers or strata committees in the audience, you may not realise that you have been effectively joined into those proceedings, even if you didn't apply to be joined or you didn't opt into the proceedings back when over 5 years ago they advertised for people to opt in. So it doesn't matter whether you've opted in, but if you have a Luca bond or Vitra bond on the building and you obviously got issues about losses associated to have it replaced, the industry, the residential market has moved really slowly when it comes to dealing with the removal of cladding. So a lot of buildings that know they've got cladding, their insurance premiums have gone up because the strata insurers don't want to insure the risk, but they still haven't removed the cladding because they don't want to spend the money to remove it. Well, they could be coming into a bit of a windfall in relation to obtaining some money towards replacing that by they can opt in relation to the cladding class action now, or let them know, because even though haven't opted in yet, they're being represented in this court case and will be so up until the conclusion, and then they start dealing with the settlement proceeds. So if you're in the audience and you've got cladding issues, and you've got a Luca bond or Vitra bond, and whether it's still there or whether you've replaced it, you may find that you're entitled to a payout shortly, because this hearing has been scheduled for 2 months. I don't know if it'll run at 2 months. I don't know if it'll be appealed, but it might be time to check your records to see what class of cladding you did have and whether or not you would be able to put your hand up for some money in relation to that cladding. Now, Project Remediate was a New South Wales initiative, very different to the other states, where they offered compensation for the cost of the cladding to be replaced, to try and spark up the residential sector to get it removed. But in New South Wales, they introduced a thing called Project Remediate, which was basically a 10-year loan interest-free arrangement, where if you had used their engineers, their contractors and their scope of works, you could have got access to a 10-year interest-free loan. The take-up in relation to the numbers for Project Remediate is not a huge amount of buildings. I think this is because they went to the market and got a privately sourced quote, and it was like the 10 years interest-free versus the actual total principal sum following the scope of works, engineers and contractors to be used wasn't as attractive. But if you've got into Project Remediate, that's fine. Just bear in mind that you do have to get 2 quotes for anything over 30,000. So even if you go down the Project Remediate pathway, you've got to get a quote privately sourced. But if you did sign a contract to get rid of the cladding before the 30th of June 2021, you can apply to Project Remediate if it was a Class 2 building and the cladding was removed due to safety reasons, to get from Project Remediate the interest that you would have paid, that it would have otherwise had to cover for you during that 10-year interest-free period. So, if you have replaced your cladding in the audience and it was done prior to the 30th of June and you're a Class 2 building, you could make an application to Project Remediate and you could get 10 years worth of interest on that loan facility paid to you. Just be aware though that if it wasn't replaced properly, you might find that you will have a building work rectification order, which is like effectively an order that the council might issue against a building to comply with a fire upgrade, to actually have the cladding replaced because it wasn't replaced or fixed properly, or they might have used the wrong product. One of the things that happened, which was a bit of a problem and still a problem today, is that initially Fair Trading had said that cladding, as a replacement product with a polyethylene core, so like petrol core we'll call it, between 8% and 30% was okay on a Class 2 building more than 3 stories. However, subsequent findings have found that that's not okay. So you might have replaced the cladding, you put on an inappropriate substitute cladding following Fair Trading's guidelines, but which have then subsequently not been corrected, and it's still available on the website. And so that could be a problem for you, which you want to seriously contemplate before you go and apply for the interest payment from Project Remediate, because they'll be investigating whatever product you put on there. But I don't know what will happen to you in that regard. But yeah, just make sure it's been replaced properly before you apply, because otherwise you get a Building Works Rectification Order, and instead of having to just pay the interest, instead of being repaid the interest, you'll be paying another principal sum to have the cladding replaced again. So just talking about orders as well, so a lot of buildings have been through defect matters. We've acted for over 500 different owners corporations over the years in relation to defect matters, and we'll generally recommend that you obtain a rectification order over a money order if the application's in ANCAT. And that's because in our experience, we find that if we get a cash payout for the owners corporations, they're not skilled at how to address the engagement of contractors to do the work, or how to prioritise the work. Sometimes I'll sit on the money for a year or two before they get on with it, and by that time prices have moved greatly and the sum that they've obtained won't be enough to replace the problems that have been caused by the defects. And so we prefer that the original builder come back to rectify the defects so the owners corporation isn't lumbered with the problems associated with getting the work done by themselves or their own contractors. But frequently what we find is that the builder will agree at the death, and I'll walk you through the process. The builder will agree at the death of the proceedings to the rectification order, and you'll file consent orders there, or they won't agree and you'll just get a consent order, an order made by the tribunal. Now, the question then arises is, well, that rectification order will set a timetable, but what if they don't comply with that timetable? Well, there's a bit of a problem with NCAT at the moment, in the sense that you can't simply just go and get that timetable extended to give them more time. You've got to cash that order in, so you can then apply to the tribunal to cash the order in, so they can convert the rectification works order to a cash order, and then you have to go ahead and do it that way. But don't let that non-compliance with that order go on for more than 12 months, because you could find yourself with some problems in actually being able to apply to get that order cashed in. So if you've got a rectification order and it's not being complied with, you need to get some advice quickly about how you're going to cash that in. And that means to make it a money order, and then you get that order paid for by the builder or the developer, whoever it was issued against. So we talked about your statutory warranty may have passed. There may not have been a statutory warranty because it was a commercial building. It may be that your statutory warranty period for your minor defects has passed and you're in time for the 6 years, which I mentioned before. Or it may be that you were letting Project Intervene address your defects and they didn't get addressed, and now the statutory warranty period's lapsed. So what do we do next? Okay, this is a more complicated action in relation than compared to a statutory warranty action. In a statutory warranty action, you just need to prove the defect, and establish a scope of works, prove your losses, and that's it. And the standard to which the work had to be done was to an impeccable standard. And so that's a cheaper, easier, quicker case. But if you miss that statutory warranty period, and it can be missed by as much as 1 day, there are various methods at the end of the 2-year period or the 6-year period. If you became aware of certain things within the last 6 months of that 2 or 6 year period, that you could have an extra 6 months to commence that action. That's called the extension period. But assuming that the extension period's lapsed and or that the warranty period's lapsed, your rights are under the Design and Building Practitioners Act, and this, assuming that you don't have home warranty insurance as well. There are other rights as well, like in that cladding class action, that's under the Australian consumer law in relation to, false representations in relation to the suitability of products. So you do have other rights and actions, but an owners corporation will typically consider an action under this new Design and Building Practitioners Act duty of care. And so this is like a negligence action. So this isn't as great a right. In New South Wales, there was a cladding case, and it was found that, the use of cladding via wood, the same product that you see at McDonald's, was found to be a breach of statutory warranty because it needed to be to an impeccable standard. But if that was a case that was being run under this cause of action, being a negligence action, it's not as high an impeccable standard. If everyone was using that sort of product, then that was to the standard of the professionals at the time. Well, then it wasn't a deviation below the standard, and they're not liable in negligence, so that wouldn't have won. So you just got to understand that this isn't as good a right as a statutory warranty right. And there's been about 11 key cases so far which have tried to help explain what that actually means. I'll just give you some of the key points here. So a plaintiff alleging a breach of duty of care under the Design and Building Practices Act must specify and identify the specific risk that the builder was required to manage and the precautions that should have been taken to manage those risks. Now, in a statutory warranty claim, you just got to prove it's a defect. You don't have to establish those requirements. So what was the builder required to manage? What precautions should have they taken? So you don't have to establish that the builder failed in those two issues, right? In the Design and Building Practitioner Act, duty of care, you do. Now, what's really powerful about this duty of care is, let's say that you had a builder that you're bringing an action against, or a developer, and they went insolvent, and so there's no more statutory warranty rights. Well, you could bring an action against the person who had substantial control of the works. So if you had if you had a director of the building company who was involved, and he had substantial control of building works, you could bring an action against the builder in his personal name and go for his personal assets, regardless of the solvency of the company. So this is a really powerful leap forward in relation to a negligence action, because this hasn't existed in New South Wales before as a piercing of the corporate veil. So that can occur if the person's got substantive control. There has been various cases where those directors have been found personally accountable, or as a supervisor of the company particularly. Another different thing about this versus statutory warranty type of claim is that you've got to plead the cases, you've got to state your case with a lot more details, like the specific risks that are required to be managed and the precautions that should have been taken to manage those risks. So that's when you're pleading your case, when you're first filing it. If you fail to identify those things, then you can have the pleadings struck out. So that can be a problem that you've got to manage as well. Now, what's also really important about this Design and Building Practitioners Act duty of care is it goes beyond residential building works. It goes to any class of building works. So commercial strata scheme, for instance, short-term letting strata scheme, for instance, would have rights under this duty of care. So this is another really broad extension of rights for consumers, which is very beneficial. And what was interesting is that the tribunal has held to date that it has the power to hear these Design and Building Practitioners Act cases. I've got a feeling that there'll be some challenges to that in the future, and they'll have to be decided by the courts as to whether the tribunal's got the jurisdiction, but we'll wait and see what the courts say. Interestingly, a lot of people would think that, well, a builder's got to ensure that it's built in a compliant manner. Well, courts don't say that the actual duty of care doesn't impose an obligation to ensure anything. So you've got to establish through your evidence that there was an obligation, that someone had to ensure that something be done. A lot of people want to have a go at the private certifier, thinking that they had the role of the certification of the work. Now, a lot of people think that this title of private certifier, that they're actually certifying the work. It's probably a misnomer, and it's probably not the correct title for their work. It's more like a person who aggregates certificates and does a few inspections to determine if certain criteria were met, but not certifying the works. So it's more like an aggregator of certificates and checking certain steps were met. And so it's really hard in New South Wales to sort of certify it. Actions have tried and actions have failed. They're not aware of any successful action against a certifier in the last 10 years by a second owner of land. So, but if you did, you had to show that they had substantive control of works, which isn't really their genre of their contract. Now, a nominated supervisor, this person will generally have substantive control of the works. And so these people have a great amount of liability. They can be sued in their personal capacity, even if their employer went broke. And so a lot of people who simply put their name to being a supervisor on site and aren't taking full control of the site, taking a whole lot of responsibility and liability for the works, because they'll be liable for not properly supervising the works. There's lots of cases against them being sued and some reported decisions as well. And the person who does the building work is required to perform the construction works in accordance with the BCA and the relevant Australian standards. So that's an interesting development. They've found that that was the case. This was followed on from a situation where a facade engineer had told the person 3 times to do it a particular way, and they refused to follow that direction 3 times. They said, well, you had to follow the BCA. You were told on numerous occasions you didn't do it. Now, under the duty of care, normally, in a negligence action, if someone else if you'd subcontracted with somebody else to do the work, you were jointly doing the work with someone else, you could get some claim for contribution for the loss from that person as well. Now, in New South Wales, there's been a matter that has raised itself to the High Court on this point, and so we'll know more in the future about whether that person you're suing can try and cut their liability down to blame somebody else that they had subcontracted to. So that's yet to be decided. And we find that just on the trend of the decisions, that the District Court appears to be more a place where you're a lot more likely to succeed on this duty of care than in the Supreme Court based on the decision making and the applications lodged. So this is what you rely on when you can't rely on your statutory warranty. So as you can see, still evolving area of law, matters are still in the High Court. It's a lot more difficult. There's more defences. It's not to the same standard, and it requires further evidence and better pleading. So it will cost more, take longer, with more risks, but it still has prospects. Sometimes you'll walk into a situation where the owner ignored the defects and you sold the property. In New South Wales, doesn't really make a difference in relation to the Owners Corporation's ability to claim for those losses. Back in there's a case of Strata Plan 94351, I think it was, where defences were being run to say, well, if the owners knew about these defects, they had these defect reports and 50% sold, then the defects claim would have been reduced by 50%. Because these people bought on notice and they got a reduced price as a result of it. That's currently not an issue in New South Wales, although that may rear its head again under this the duty of care factor. So quite often people will want to know, well, what does it even mean going to court? What are the sort of steps? What's the process? What's this journey that I'm having to go through to get the defects fixed in a building that I paid top dollar for? And why have I got to do all this? Well, owners' corporations always have the option to just pay and fix the defects themselves. Alternatively, there may be some insurance there because the builder's gone insolvent. In New South Wales, in order to rely on your home warranty insurance, you've got to have the builder who could be deceased, insolvent, or a money order outstanding against it from a court or a tribunal. Now, in order to rely on that insurance, or if there's no insurance, in order to get somebody else to pay for the defects because you don't want to pay for the defects, you'll need to look at this process. So you're going to, prior to lodging a claim, you could, unless you're going to court, you could decide to make an OFT complaint to the Office of Fair Trading. Our office has found that these is more like a preliminary step, doesn't resolve the matter. There's always unresolved things and the matters always go on. You can make an Office of Fair Trading complaint. It's like a licensing investigation. They send an inspector out and they'll determine whether or not certain things should occur. That could take a couple of months, could take longer. But then you'd be looking at filing your application in NCAT. Now, you can file in NCAT without going to a fair trading complaint if you've only got, if you have less than 3 months left from the expiry of the warranty period. At the moment, we're running a Supreme Court action to work out whether or not the tribunal was correct in striking out a claim because it wasn't satisfied that the complaint hadn't been lodged. And so we'll know more about whether the tribunal actually has the power to strike out claims where they're not satisfied about certain elements of complaints being lodged and expiry of warranty periods. However, prefer to work where possible within the bounds of the directives of fair trading and the CCCCC and NCAT. And so eventually you'll get to the point where you're doing a complaint or not. So you don't need to do a complaint if you're going to the Supreme Court, and you don't need to do a complaint if the warranty period has less than 3 months to run. But you file the application, you'll typically have got your report. That report might have taken some months to obtain. It might be that you didn't get enough time to get a full comprehensive report and you've just got a list of defects and filed based on that because of the lapsing of the 2-year period, which is pretty short. Just bear in mind that if you're looking to use the 2% bond scheme, that you can't use the report from the 2% bond scheme in your claim for breach of statutory warranty, so you've got to get that sorted out on your own basis. Bear in mind that the developer's paying for the report under the 2% bond scheme, and hence part of the reason why you're not to use it. It's not your evidence. But the claim's filed in the court. There's usually about 6 weeks passes and they have a directions hearing. And that means where the parties are required to meet and work out how they're going to conduct the hearing, how they're going to conduct the giving of evidence, whether there's joint reports or joint conclaves. And then they'll set a timetable, and it might be that the owner's corporation has 3 to 6 months to get all its evidence filed, and then the builder or developer or whoever the defendants are will want to have their evidence in reply, and they might take 3 to 6 months to put evidence in reply. And then you'd look to ideally have a conclave, because you'll have, say, a typical case, we'll have, say, 200 defects. So you put the two experts together, whatever their genre, whether it's fire, general, waterproofing, whatever, try and get them to agree as much as possible. So those 200 defects might break down to, say, 50 defects that are in dispute, because the experts are able to resolve that, yeah, there's a problem with 150 items, there's 50 items that we can't resolve that there's a resolve, or concede that it's a defect, or agree on a scope of works. And so that's the idea of a joint conclave. We're trying to get the experts to resolve as many items as they can by agreement. And then that's a really good point in time to have a settlement. Now, you've got the joint reports, you've seen where the point of agreement is, you've got the extra 50 items, you're trying to work out what compromises can be made in relation to those extra 50 items. You might go and do some invasive investigations, so other forms of water testing, and then you look at a settlement. And if you try and do it before you've got your expert reports, it's too soon, because you don't know what the 200 items are, so you can't really settle those. But it can be progressed at any stage settlement. The better informed you are about your concerns, and the more time you've given the developer or the builder to think about those concerns, the better the outcome will be at a settlement discussion. Those can be held on site, representatives' offices, or they can be held with the court or the tribunal or a specialist venue. Can be over parts of the dispute or the whole of the dispute, can be in relation to certain aspects of the dispute, and then the rest of the dispute can continue on where you're unable to reach agreement, and you'll want to have the agreement documented, all sorts of aspects taken into account, whether it's new builders doing the work because the original builder's gone insolvent, dealing with home warranty insurance, potential for Design and Building Practitioners Act compliance if it's not the original builder doing the works, work health and safety obligations, and costs of checking the works are done in the future, and who's going to pay the legal costs as well. So these are the sort of things you try and cover in a hearing. But if you can't get a hearing, if you can't get a settlement, well, then you'll have a further directions hearing where there'll be some further evidence in reply to the joint reports. Then you'll have a final hearing after that, and the decision will be provided by the tribunal. And as I last understood it, the tribunal had a timetable of 3 months to give That was what their objective key performance indicator was from the date of the hearing to issue their decision. And then there's a 28-day appeal period from that. And then after that appeal period, if that is lapsed, then and the builder doesn't pay the amount, well, then you can do a home warranty insurance claim because that's a trigger point, assuming it was a 3 or less story building, or then you might have to look at enforcing the debt through other means if they're refusing to comply with the orders to pay the money, or if you get a rectification order, which is if you're in the tribunal, the Supreme Court and District Court can't issue rectification orders, they don't have the jurisdiction to do that. Then you've got a rectification order, they've got to comply with that. If they don't comply with the terms of that rectification order, we then want to reach out to your lawyer and say, look, we need to cash that rectification order in before it's too late. He's not complying with the terms of the order. So this is just an example of the types of time frames. These things will vary widely. They can deal with quicker, they can deal with a lot longer. And the bigger the building, the longer it's going to take. There's more units to inspect, more issues likely to arise, more costs involved. One of the things that has just changed in relation to the evidence for NCAP matters, and this is not in the Supreme Court, is that there's a new expert witness code of conduct. And so if you're in the audience there and you've got an expert who's currently got a report in draft or has currently been engaged to prepare a report, they're going to need to do it in accordance with the new expert witness code of conduct, which requires more consideration of more items and more evidence. So you want to quickly get them rebriefed to provide the right evidence, so their evidence doesn't face challenge in cross-examination about its inappropriateness, and it affects its weight if it's not inappropriate, if it is inappropriate. So you can scan that QR code there, and that'll take you to an article that we have, which explains more about that new expert witness code of conduct and the differences between the new and the old one. If you scan that QR code, it'll take you to our defects ebooks, which you can obtain, and there's more information there about what I've discussed today. And if you search our website, there's even more information again.
Is the building defects claims timeline the process for all class of buildings, as well as up to and over 3 stories?
Okay, so the statutory warranty start time is the same regardless, but it's only for class 2 or class 1 houses, right? So it's only for residential building works. So it's not for class 3 or 9C, say, aged care or short-term letting. So the duty of care, the start date for bringing your action for that, because you've got 6 years to bring that action, is when you ought to have been aware of the defects. Now, for an owners corporation, bringing an action, well, they can't ought to have been aware until the owners corporation was created. So they're not going to be aware earlier than registration. But you can be aware of defects before you get a report, because obviously you thought there was a problem, and that's why you got a report, particularly if there was water leaks occurring. So that ought to be aware can run before the date of a report. So always try and be conservative, because again, the number one defence for somebody is that you weren't entitled to bring the claim. And if you're not entitled to bring the claim, then the claim gets thrown out of court, and you get typically, in the cases that I've seen, you're ordered to pay their costs, and because the claim was unsuccessful.
Our 14-lot strata scheme has a top floor unit requiring waterproofing repairs to 2 exposed balconies under the Design and Building Practitioners Act. Our strata manager advised us to appoint an engineer to oversee the full remediation process. Is this mandatory, or can we involve an engineer in just the initial scope of works and the tender process? Is that sufficient to comply with the Design and Building Practitioners Act?
If you go to our website and you go to the search function and you type in the word comprehensive, it'll take you to a guide, which is called a comprehensive guide to the Design and Building Practitioners Act, and it sets out all the steps there. So the designer is only required where, in that circumstance, to do the design. There is no requirement that the owner's corporation enter into a contract with that designer, which is otherwise known as a design and construct contract. So there's no requirement for such a contract, which is where the designer checks the works at certain hold points and then, issues certificates of completion or non-completion or directions, right? So there's no requirement for that contractual type of arrangement. But they'll need to use a registered building practitioner, and then the designer makes declarations to Fair Trading and uploads through the Construct New South Wales website about the design, and then the building practitioner will make declarations that they did works in accordance with the design. But it's certainly creating a lot of problems and escalation of costs, because when you seek to comply with that legislation, you'll find that, like we did a survey with SCA New South Wales, that simple jobs like that, to comply with this legislation, was causing an extra, on average, about 7 months delay and about an increase in 170% in costs. But the work quality was the same, effectively. So SCA has lobbied that there be an expansion of the exemption requirements, because patchwork could suitably fix these items without having to replace the whole membrane and the tile bed and, lap it up and down and into the drainage hole and over the hob and stuff like that, like completely overwork the situation. So it's causing unnecessary financial costs. And when you actually think about that, because then if you look at the way that Fair Trading prices home warranty insurance, that normally for home warranty insurance, you pay about 1 to 1.5% of the contract price, but owners corporations, where when you break the contract price up, say you break the contract price, so that's $300,000 amongst 10 lots, because it's more than $20,000 per lot, each lot gets $340,000. So that $300,000 job gets $3.4 million cover. And so instead of paying 1.5% on the contract price, they pay 10% on the contract price for home warranty insurance. So there's another escalation in costs there for that as well. So this scope of works is driving the costs up, and then you have to add that as well. And if the works exceed $150,000 and required an occupation certificate, you've got to pay a tax to Fair Trading to administer the process, in addition to the increase in stamp duty as well. So that's another further escalation in costs as well.
And I believe there's concerns about the timelines as well, and it's really extending the timelines out on the projects.
Yeah, well, that's causing problems with the insurance market, because they're saying you've taken too long and we're going to not insure you for that item, or we're going to increase the premium, or both, typically both.
We have ongoing water ingress issues in the building's external facade. The issue persists despite repeated attempts by the owner's corporation's contractor to address the problem. Are there specific regulations or guidelines that outline the proper procedures for dealing with building defects, especially when the owner's corporation lack expertise in construction? Given the contractor's failure to resolve the issue, does the contractor bear any responsibility? Is this project covered by a 6-year warranty? And as a lot owner, am I obliged to accept the repair proposal approved by the owner's corporation, even if I have concerns and they refuse to consider alternatives? What steps can I take to ensure a permanent solution is implemented?
Okay, well, if you have a look at those guidebooks that I referred to, the same principles regarding claiming against a contractor apply as claiming against the original building contractor and or developer. So there's home, but you do have the benefit, assuming the contract price was over $20,000 of home warranty insurance. And so the insurer needs to be notified within 6 months of being aware of the defect in the remedial works. So that's a stage that they want to do there. The problem for an individual lot owner is that they're not a contracting party to the remedial works for common property, because that would typically be the owner's corporation. That might be them if they had an exclusive use bylaw with permission to do the works and did the works, but assuming that's not the case and it was the owner's corporation contracted with a contractor. So it's a matter of getting the owner's corporation to enforce the warranties and notify the home warranty insurer. As to the scope of works, the owners corporation doesn't have to do a perfect Rolls-Royce job. They've just got to do a job that's satisfactory to resolve the matter. So unless you can establish that the works will not be resolved satisfactorily, you should allow that to progress. Otherwise, you're bound to be just found to be interfering with the solution. But if you're suffering a financial loss as a result of all this, like a loss of rent, because you're not unable to rent the property, well then under the strata legislation, section 106, and if you go to our website and type in section 106(5), it'll take you to a list of cases where owners corporations have been ordered to pay all sorts of things, damage to carpets, curtains, loss of rent, pet relocation fees, all sorts of stuff like that, where someone suffered a financial loss. The owners corporation's bound to pay for that loss, and they can seek to recover that loss from the builder under the contract as a reasonably foreseeable loss.
Thank you so much, David. We're just about at the end of the session. We do appreciate you spending this time with us, especially when you've provided such great information.
Thanks, everybody. Good luck on your search for information, and thanks, Nikki, for being a conduit for helping all these folks.
If you gained value from this video, please hit like and subscribe to our YouTube channel. If you're looking for information about parking, strata insurance, defects and more, head over to lookupstrata.com.au or sign up to our free weekly newsletter via the link in the description box below.